So in California, by law, landlords must go through a court process to evict tenants. The process is designed to be very efficient and really to provide consistent results for landlords to be able to eject tenants from and recover their properties. And there's often very little regard for outcome for the tenants. Eviction lawsuits are fast-tracked. Nearly 75% of eviction cases are resolved within 45 days of filing, and nearly 60% of those are resolved within 1 month. So I just want to highlight how quick they are. When a tenant is served with an eviction lawsuit, the tenant has only 5 days to file a response in court or risk losing their case and therefore their homes by default. So in the vast majority of eviction cases, landlords are represented by attorneys, and the vast majority of tenants are not represented. And because of this, even when a tenant has strong defenses to an eviction, if they don't have an attorney, they're more than likely going to lose their case. Now, because evictions proceed so quickly and there are so few resources for low-income tenants to get meaningful help when an eviction is filed, evictions have played a significant role in creating California's affordable housing crisis and our homelessness crisis. Now, despite the statewide moratorium and local tenant protections, we have heard reports of landlords still attempting to displace tenants from housing using a variety of methods, including calling the police, trying to trick tenants into leaving by serving them with papers that look like they've been issued by the court but haven't, or simply by changing the locks. I want to stress that all of these methods are illegal. And in the instance of calling the police on tenants, we're having a national conversation on the relationship between police and communities of color, and particularly Black communities. So we can even, this behavior is actually dangerous in many instances. Now, landlord groups are also fighting, their associations are fighting eviction protections in court and have been attempting to challenge these rules. We're confident, though, that the emergency measures that the local governments and that the state court leaders have taken are necessary and reasonable in light of the pandemic. But we do need to think about what we need to do to help people stay in their homes when these temporary measures end and tenants have to pay rent owed. So for that reason, and just the fact that the massive unemployment rates and limited government aid, which the other presenters have covered in detail, when the rule is withdrawn and the moratorium lifts, we expect this massive eviction crisis. And if we allow the evictions to simply start again without any long-term assistance, it's going to have a devastating impact on renters and in particular communities of color, right? So for that reason, Western Center, we're co-sponsoring legislation, Assembly Bill 1436, which is called the COVID-19 Eviction Prevention and Housing Stability Act. At core, this legislation is designed to give tenants a fair chance to pay back rent owed, and preserve the ability of landlords to pursue unpaid rent through civil actions as opposed through the eviction process, which is currently the case for unpaid rent that is more than a year old. It also contains protections for renters from negative impacts to credit and therefore the ability to rent in the future. So this legislation is a chance for communities. AB 1436 is a chance for communities and individuals to tell their state legislators here in California to stop the looming wave of evictions to keep us all safe and housed. It is, I want to stress, the first step of many that we need to take to bring more equity into housing in California. But this is a great way for people to become engaged.